enjoy absolute immunity for acts that he does while in office, I presume, and I know we're sort of going through things right now, that are related to his duties in public office. We've got a special report that we are standing by for, and as soon as we're going to throw the special report for you.
This is a CBS News special report. Good morning, everyone. I'm Major Garrett. We're coming on the air with breaking news from the Supreme Court, where the justices have just ruled on whether former President Donald Trump has absolute or qualified immunity for conduct involving his official acts during his time in the presidencies. The former president and his defense team made the argument that a president, not only former President Trump, but any president, has absolute immunity, this after he was criminally charged with plotting to overturn the results of the 2020 election. The import of this case simply cannot be overstated. How the justices' rule could well define the parameters of power of the American presidency and have something to say about the future of our very democracy. CBS News chief legal correspondent Jan Crawford has been reading the ruling. Jan, what do we know?
We know this is a 6-3 ruling written by the Chief Justice that says flatly presidents are immune, absolutely immune for their official acts. That means acts that they take under the arbit of their office as president. But, and here's the big but and why it's important for Donald Trump, they do not have that kind of immunity, as you said, for their unofficial acts. So then what does that mean? What is an unofficial act? And the court, in its opinion, gives some guidance on how the courts can draw those lines between official conduct and unofficial private conduct that a president can be prosecuted for. There is a scathing dissent by Justice Sotomayor, joined by the two other liberal justices. This is not an outcome that John Roberts would have preferred, saying that she is now fearing for our democracy. So we, again, are just getting this opinion. I will be reading how the court has drawn this line. Based on what I'm seeing in Roberts' decision so far, I do not believe right now the court has closed the door off to prosecution of Donald Trump for those unofficial acts, as the lower court had outlined in a separate case. But there is guidance in here, and Major, we're going to have to take some time to look at that.
So based on your initial reading, Jan, you do not interpret this ruling as foreclosing Special Counsel Jack Smith's prosecution of former President Trump on evidence and charges related to January 6, 2021.
If what the guidance they say in this opinion right now suggests that some of that behavior is an unofficial act, which is what Trump's own lawyer conceded during the oral argument, a number of things in terms of submitting fraudulent statements to court, submitting fraudulent states of electors, he conceded those were private, unofficial acts. So based on this quick run through, that suggests those still could be possibly open to prosecution. However, I also want to look at Justice Sotomayor's dissent. She was not on board with this argument. She believed that even having any immunity whatsoever was dangerous for the country, that there were other ways that presidents, our democracy could deal with that, and that we didn't even need to be getting into this. So at the very least, we need to look at that.
Jan, let me
but right now, these are the two lines. It's what we expected between official and unofficial.
In a broader context for the court itself, it's a fraught moment for the court. Much of its public interpretation has suffered in the last couple of years, people finding it, to their point of view, more political than they are comfortable with.
Well, no question.
And in that atmosphere, a 6-3 decision on a matter of this import, how does that land with the Chief Justice? How do you think that will be absorbed by the country at large?
This is not the decision that John Roberts had hoped for. I mean, he would have hoped for a unanimous decision similar to what we had in the Colorado case when the court ruled almost unanimously, and certainly in the judgment, that Donald Trump could not be removed from the ballots in states. That is what they would have hoped for in this case, and even in the case on Friday, when a case that did not directly involve Trump but will affect his trial on whether he can be charged with obstruction of an official proceeding, one liberal joined with the conservatives. This one is straight ideological lines. You've got a very fierce dissent by Justice Sotomayor, joined by Justices Kagan and Jackson, suggesting that what the court has done today is potentially dangerous for democracy. That she is, and if you just go to the last line, I just had skimmed it. She is fearing for our democracy. She is dissenting. That is very charged language, very unusual.
Jen, I'm going to let you continue to read. Scott McFarland, I want to turn to you because this decision was waited for by the nation, but specifically here in Washington, D.C., by the special counsel and his team and the district federal judge, Tanya Chutkan. What do you imagine this ruling will do to the calendar as it's understandable this morning for that case, January 6th, and former President Trump?
The bottom line has always been, can they get a trial in before the election, before November 5th? As the court spent all this time reviewing the matter, the prospects dimmed. It was a long shot going into this day, like drawing an inside straight at the poker table. Based on the initial read, it looks like it's a longer shot, like winning the lottery, because some of this has to go back to Judge Chutkan, the district court judge who's been assigned the trial. And she may have to go through what's an official act, what's not an official act in the indictment. That's going to cost more time. That's going to cost more hearings. It's going to cost more bandwidth in a courthouse where they had just a narrow window to work with in the first place. Judge Chutkan has already said when she gets this case back, she's going to give both sides 2 to 3 months to get ready for trial. So if it goes back to her today, there's 2 or 3 months she's going to give both sides anyhow. That brings you into September, maybe into October. Now there are a whole bunch of bear traps that the Supreme Court may have set for her that slows things down more, where she has to go through hearings, requests from Trump's team to stay the proceedings further. Really looks like the longest of long shots to get any part of this trial in before November 5th.
Scott, you've been in the courtroom a lot. You've watched the entire progression of this case. I've listened to and read some legal experts saying if the court does as it did, there were some who interpreted this in advance, this ruling, there might not be a trial, but there might be a pre-trial hearing in which evidence not known to the public yet, but presented to the grand jury that formed the basis of the indictment might become aired in full public view. Is that a possibility as you see it?
It's an intriguing thing. Judge Chutkan could order a hearing on one of these matters. Was it an official act? Was it an unofficial act? And at that hearing, the special counsel could present all kinds of evidence with which we're not familiar right now. All kinds of revelations, maybe witnesses from whom we haven't heard. So maybe no trial, but maybe there are things America could learn through one of those hearings. Maybe it could be theatrical. Put that aside. Judge Chutkan has done something over the course of this case that's noteworthy. She has been crisp with timeframes. She has moved diligently through all of the hurdles Donald Trump's legal team tried to erect to slow down the case. She moved nimbly early in this case, and she has said in so many words that democracy remains at risk. She has said that during January 6th sentencing. She has been unequivocal in stating what's at stake when you talk about January 6th.
The hardest job at this table is carried out by Robert Costa, our chief election and campaign correspondent. I don't want you to give me the instant analysis, but how do you think this ruling, based on what we know so far, Robert, will land in Trump world? How will it be characterized? And what do you think, at least initially, the political impact is probably to be?
It's important to step back and look at the full context politically here facing former President Donald Trump and his campaign. This Supreme Court and its ruling on presidential immunity is just one front in a multi-front challenge they are confronting as they head toward the November elections. On the federal level, as Scott has been detailing, they're looking at a possible trial on January 6th. But in terms of unofficial acts, as we've been discussing here at this table, there's also a possible looming federal trial on Trump's handling of classified materials. Now, that has been a bit stalled in the process down in Florida, but that still is a possibility of being a trial that confronts the former president, maybe not before the election, but at some time in the next year or so. And let us not forget, too, that former President Trump on July 11th faces sentencing in his criminal case in New York over those so-called hush money payments made to porn star Stormy Daniels. Trump has been convicted there. And what's happening with immunity on a presidential level with the Supreme Court is, as Jan would often detail, about federal cases. It's not going to affect what the judge, Juan Merchan, decides to do with sentencing in New York. And then you, of course, have the Georgia case that could play out at some point later this year or next year about election interference allegedly committed by Trump in Georgia. So all of these cases hover over the Trump campaign. They may feel heartened by the Supreme Court's ruling today to a point, but this is by no means the end of what they face legally.
It does not lift the cloud of legal jeopardy.
That's exactly right. It does not lift the cloud at all. And in fact, even if former President Trump feels like he's getting the weight off his shoulders on a federal level with special counsel Jack Smith, there is still a real possibility that he faces a possible jail sentence this year, or probation, or house arrest to some extent. And that could happen at some point. That could affect the Republican National Convention
days before
in
the Republican National Convention.
July 11th is the sentencing date. The Republican National Convention starts the following Monday.
We promised you that Jan would continue to read and sift and analyze. Jan, what can you tell us?
Well, I mean, I think the bottom line is that Judge Chutkan's going to have a lot of work to do. Mm-hmm. And they're giving her standards, setting out things that they believe.
Would you describe it as a roadmap, something that clear, or something a little bit more vague?
I think it's more clear, but it's still going to require fact-finding, hearings, briefing, which means time, clock ticking. So, I mean, obviously, the court is saying there are some things that sound official, like communications with the vice president that presidents have, even if you're, running for office. Some things may be unofficial, which, again, we mentioned earlier is what they ran through at the argument, that the president's conversations with outside people. Mm-hmm. And then there are some things, is he doing it as a candidate as opposed to doing it as president? But again, it's evidentiary hearings, it's fact-finding, and that's going to fall on Judge Chutkan.
Can I just build off
yes, go ahead, Robert.
Jan's point for 1 second? One of the key witnesses CBS News has learned for the possible January 6th trial is former Vice President Mike Pence.
Correct.
And his aides. And if vice presidential communication with the president necessitates an official act, that could gut, potentially, special counsel Jack Smith's case. Because remember, one of the key moments of January 6th is the night of January 5th, when Trump brings Pence into the Oval Office one-on-one and pressures him again and again to overturn the election. And Pence says, I have a constitutional responsibility to certify the election.
One thing there, Robert,
but the argument would be that some of those conversations weren't official conduct.
Weren't official conduct because...
So, again, this is going to fall,
even in the Oval Office.
I mean, that may not necessarily be official. I mean, it's a pretty high bar, but...
As we debate this here at the table, I want to bring in Jessica Levinson, CBS News legal contributor and Loyola Law School professor. Jessica Levinson, if you can, jump in on this question. So the president is having a conversation about the Electoral Count Act and certification with the vice president. The Electoral Count Act is a law. It has been passed by Congress. The president is duty-bound to follow that. If he tells the vice president, even if it's an official conversation, to somehow subvert that, what is that? Official act or private act?
So everybody's going to hate this answer, which is it depends. I think Jan has laid this out really well. Let's remember. So for the things that are just for the president, for those things that are just within the president's ambit, absolute immunity. For official acts in general, at least presumptive immunity. For unofficial acts, no immunity. So we have these three categories. And then the question becomes, and as Jan said, this is going to be the question for Judge Chutkan, how do we put information into those buckets? And Major, you just laid out one of the big questions. And so what we know from the opinion thus far is that we put meat on the bones of these standards by saying, does the president have the constitutional and statutory authority? That's what Roberts is starting with. Like, who gives him, or at some point her, the authority to act in this situation? And if they're acting pursuant to that authority, then that's something that a president can do, and that would mean it looks official. If it's something that you or I could do, if we could have a conversation with a private attorney and say, you know what, I think we should file this lawsuit, or if I could call a governor or a secretary of state in a capacity as a candidate or a private citizen, then it starts to look unofficial. So I know everybody wants, here is the answer, but I have to say, looking at this particular opinion, it really depends on looking at the Constitution, looking at the statute, and then looking at the facts of, frankly, a specific phone call. I heard Jan use the words, evidentiary hearing, looking at the circumstances. I could not agree more.
It depends.
And again, following up to Bob's point, because that's so important. And it's what Jessica, and if you want to weigh in on this too, I mean, the court is saying, as far as those communications with the vice president, they're not ruling out that those could potentially be unofficial acts, but it's going to fall on the government. It will fall on Jack Smith to rebut that. He is going to have to show that potentially those conversations that he had with the vice president when he does have no role in the certification, Trump did not, whether that would fall outside that official conduct.
Falling on the shoulders of the government. We are helped at this particular moment by having former Justice Department prosecutor Tom Dupree join us. Falling on the shoulders of the government to parse the wording and the import, the meaning, the gravamen, if you will, of this Supreme Court opinion. Tom, as a former federal prosecutor, how do you read it?
Well, look, I can't imagine that Jack Smith is super surprised by this decision. This is definitely the way the Supreme Court majority was leaning based on the arguments. And I think the takeaways are twofold. One is that Smith has to be heartened, at least that his prosecution will survive. The Supreme Court did not accept former President Trump's argument that immunity requires the prosecution to be shut down entirely. So he'll live to fight another day. Second point, this is a homework assignment of massive proportions for Judge Chutkan. There is an enormous amount of legal work that is now going to have to unfold over the next several months. That means the chances of a trial before the election are zero at this point. So although his prosecution survives, it ain't happening anytime soon, at least as far as a trial is concerned.
Jan, you have some very important language from the dissent.
Right. I mean, as we were
Sonia
talking about,
Sotomayor.
Justice Sotomayor, joined by Justice Kagan and Justice Jackson, the court's three liberals, as we were saying, it's fiery. I just thought I will give you some examples.
Please.
Today's decision to grant former presidents criminal immunity reshapes the institution of the presidency. It makes a mockery of the principle foundational to our constitutional system of government, that no man is above the law. And this was an argument that she made during the oral argument. She was very hesitant to embrace any kind of immunity for anything, suggesting when, say, Justice Alito was talking about how a bitter campaign and the winning candidate could then throw the loser into jail. They were very worried about the impact on future presidents. And as we saw in the debate, Donald Trump did suggest that Joe Biden's immigration policy was criminal. So perhaps under a Trump DOJ, if there was one, could he throw Biden into jail if he is the winning candidate? The court was worried about this Pandora's box of future prosecutions for former presidents. Sotomayor was not. During the argument, she says, if we come to that point, our democracy has failed. And there are other ways to address it. So this dissent tracks very much with what she argued. What I find notable is that Justice Kagan joined it, as well as Justice Jackson.
Tom Dupree, very quickly, as someone who knows well the hesitancy the Justice Department has always had in the question of prosecuting former presidents or even sitting presidents, how do you regard that dissent? Do you consider that, well, just what's your opinion of that dissent?
Look, I think this is a case where both the majority and the dissent were grappling with very powerful arguments for their side. On the majority's side, they, I think, very legitimately were concerned about the threat of future presidents possibly being prosecuted, just as Trump threatened during the debate. On the dissent side, the principle that no American is above the law is about as hallowed as you get in our constitutional structure. So I think Justice Sotomayor's concern definitely has force. I think if you're a prosecutor, you just kind of dust yourself off. You keep going. You've now been given this guidance. I think the Supreme Court gave surprisingly specific direction to Judge Chutkan as to how this case needs to move ahead. It's more than I anticipated they would provide. And so it does give maybe not a roadmap, but a general directional indicator as to the way that this case has to move ahead now.
Robert Costa, reaction from former President Trump.
This is an explosive political moment, as much as this is a significant legal crossroads. Former President Donald Trump has just reacted on his social media site saying, quote, big win for our Constitution and democracy, proud to be an American. There's a lot of celebration clearly happening in former President Trump's orbit because, as we've been discussing, he might not now face any sort of federal trial before the election. And the political moment here also needs to consider what it means for Democrats. This comes just days after a presidential debate where President Biden was widely seen by members of his own party as failing to hold former President Trump to account on numerous fronts, seen as stumbling on the debate stage. There has been talk about what's next for President Biden. Now, Democrats potentially could be galvanized against this Supreme Court behind President Biden because there's so much anger going back to 2022 and the overturning of Roe v. Wade. Now they see Trump's escaping trial likely this year. So you have a charged political moment right after the Democrats had this reckoning in Atlanta. Let's
talk about that. Galvanized Democrats' future of President Biden's reelection campaign. No one better to help us do that than Chief White House correspondent Nancy Cordes on the North Line of the White House with reaction from the Biden reelection campaign. Nancy, please.
Major, they're still absorbing this ruling here at the White House and at the Biden campaign, just as you have been doing around the table. But I do have, as you point out, some early reaction from a senior Biden campaign advisor who says, quote, today's ruling doesn't change the facts. So let's be very clear about what happened on January 6th. Donald Trump snapped after he lost the 2020 election and encouraged a mob to overthrow the results of a free and fair election. This person goes on to say, since January 6th, Trump has only grown more unhinged. He's promising to be a dictator on day one. Joe Biden will make sure the American people reject him for good in November. Very interesting use of words in this statement. Snapped. He's grown more unhinged. It's almost as if they are trying to suggest that despite Joe Biden's weak performance last Thursday night, that he is not the one who is deteriorating. It is Donald Trump who has snapped, who is growing unhinged. He is the one who is falling apart. There's no question that the Biden team would have loved for this trial to take place before Election Day. I think they've been resigned for quite some time that wouldn't happen. And now this ruling, as Jan has pointed out, has all but closed the door on that.
Scott McFarland, you have muted reaction from the special counsel's office.
Yeah, Jack Smith's office is not commenting on the Supreme Court ruling, which means he's not laying out a roadmap ahead for his case. He's taken the same posture during previous rulings involving Donald Trump. But it's also important to note that Judge Tanya Chutkan does not have limitless bandwidth, time, or space. She has other matters in her court. And I was just in her court last week for a few January 6th defendant sentencing hearings. She has a trial the week of the election of a January 6th defendant. All these judges are quite busy navigating these 1,400-plus U.S. Capitol riot prosecutions. So if it takes a lot of time and space to go through all these matters with Judge Chutkan, this can bleed well into 2025. But I'll also admit that I'm getting any number of text messages, I suspect you guys are too, from Democratic staffers, operatives saying, what would this ruling mean if Donald Trump wins the White House back? What would this mean for his presidency, this jolt of presidential immunity?
Jan, if I could ask you, we have duly noted the stinging dissent of Justice Sotomayor.
Oh, let's just give some more. I mean, I'm just reading this.
Can I ask you what?
The president is now a king above the law.
Okay.
That's her bottom line in her dissent. Sotomayor. Wow.
And
in every use of official power, the president is now a king above the law.
And if you could summarize the majority's opinion.
Well,
putting together this.
I'm reading Roberts now. I mean, he is just basically saying that's ridiculous, despite the dissents, rejecting all of this, what they believe is very reasonable analysis. The president is not a king above the law, and they have certainly still some immunity, ability to be prosecuted for these unofficial acts, which I agree with Tom Dupree, and I am surprised. There is more of a roadmap here than many people may have thought. I still think this means delay, and it's going to take Chutkan time, but they have given her more to work with on what does and does not constitute official acts that Trump cannot be prosecuted for. But there are still things in this indictment that Jack Smith is going to, and I would guess he anticipated this ruling and he already has his papers ready to go, is going to say there is enough in this opinion that says we can still go forward with this trial.
Scott, it's quite possible during some of these hearings, some of these matters that go back to Judge Chutkan, that Donald Trump might have to be there in the courthouse for them. He is a criminal defendant, and it is a criminal case matter. It's less clear to me that it's necessary in all cases, but you do have the prospect sometime before the election of Donald Trump walking in to the Washington, D.C. federal courthouse, or more likely being shuttled underground through a private entrance for a criminal matter in a federal criminal case. These hearings do give the special counsel the chance to make some type of argument about what he says Donald Trump did.
And I agree. But I also think, and to your point about, some of the reaction from what we've heard from Trump already, I mean, this is a win. for Donald Trump. And I do see, based on this ruling, it seems very difficult that there will be a trial this year.
Jessica Levinson, the president, that is the former President Trump, called this question, asserted this broad articulation of presidential immunity. Has the court for this time and for all future times clarified either those bounds or the limits of prosecutors pondering whether or not to bring a case against a former president?
Well, I think they've done both. This is a matter of first impression. We had what the rule was with respect to civil suits regarding presidents and official acts, but it was an open question in constitutional law as to whether or not there was going to be immunity based on criminal prosecution for official acts. And now we have, I think, much more guidance than we thought we would have even 15 minutes ago. So the court did not go with the former president's broad argument here. It's not near that, but I agree with Jan 100% that I think in a lot of ways this is a win for the former president. And it is absolutely a case that's not just about Trump, even though there's a lot in here about the indictment. This is about every other future former president and future president and what type of immunity they enjoy from prosecution.
Tom Dupree, it's not a closing argument, but I give you the final word.
Well, my final word is, look, I think by and large this is a win for Trump, but at the same time, the Supreme Court rejected both extremes. It carved out a middle ground. It provided guidance that will be used for the ages, not just in this case, but in any case involving a future president. I suspect the Chief Justice's one regret from today's is that he wasn't able to break up the usual political deadlock that plagues the Supreme Court of having the 6 conservatives on one side, the 3 liberals on the other. If there ever were a case where you hope he could assemble a more robust majority, this would be it. But perhaps it was inevitable given where we are in the year 2024.
Tom Dupree, that is actually the next to the last word. Robert, you get the last word.
We are watching history unfold. This is not about red versus blue. This is questions of the Constitution, what the framers intended about presidential power. We are in uncharted territory legally, politically, constitutionally. Buckle up.
Robert Costa, Scott McFarland, Jan Crawford, Jessica Levinson, Tom Dupree, thank you very much. A quick recap of today's historic ruling. The Supreme Court, in a 6-3 decision, has ruled that presidents do have immunity for prosecution for official acts. The justices also decided to send former President Trump's January 6 related case back to a lower federal court for further consideration. What does that mean? It is likely that we will not see a trial in this case before Election Day in 2024. Now, some of our viewers will rejoin CBS Mornings. Our coverage will continue on CBS News 24/7, your local news, and of course tonight on the CBS Evening News. This has been a CBS News Special Report. I'm Major Garrett. Good day.
Well, you've been watching a special report. The nation's highest court has ruled that former President Donald Trump is entitled to some level of immunity from federal prosecution for official acts he took while in office. So we have a team of reporters and lawyers standing by to discuss this monumental decision. And we're going to start things off by bringing in attorney and former federal prosecutor Scott Frederickson joining me now. Also, we've got Katrina Kaufman standing by right there, but we'll talk to her in a little bit. So, Scott, let's dig into this. So this is very interesting. The conclusion was that indeed the president enjoys absolute immunity for his core constitutional powers. There's a difference between official acts and unofficial acts. But in the gray, there may be some interpretation. What's your reaction to the initial reaction to the ruling?
Well, it's a ruling of historical constitutional impact. The Supreme Court has adopted a fairly bright line rule protecting the president's executive branch powers. So while the president does not enjoy absolute immunity, the court rejected the argument of the former president that he enjoys absolute immunity. The court does say the president is immune from official acts and goes on to say that includes acts at the outermost perimeter of his official duties. And that the prosecution or the government may not inquire into the motives of the president for that. Now, the court went on and essentially said this goes back to the district court. Judge Chutkan now has to make findings between what's official acts and what's private acts. What's interesting here is the court went on and said, look, the conversation between the president and the vice president about whether the vice president would certify the election, that's within the official acts of the president. So that's clearly out of the indictment. Then it turned to two other areas to give guidance to the district court. One is it indicated that the president's activities with regard to the private slate of electors, the fraudulent slate of electors, as they have been referred to, the bogus slate of electors, that may be a private act, may be an official act. That's one of the things the Judge Chutkan has to determine. Likewise, it said, look, the president enjoys power to speak to the people, but in the conversations about that the president had alleging that the election was stolen, that's also something that the Judge Chutkan has to make findings whether those activities falls within official acts or private acts. So this goes back to the district court for hearings. Now, let me add something else. I think what we're going to see a couple important things. One, Judge Chutkan is going to schedule hearings very quickly. Two, I think we'll see special prosecutor come up and trim down his indictment right off the bat. He's going to walk in the court and saying, look, I'm paring down my indictment. I'm taking out anything that might run afoul of this Supreme Court ruling. I'm only going to go with the charges that, in their view, are purely private, and then jump into the hearings that way in an attempt to move the hearings in a kind of fast-forward fashion. That said, it's hard to believe, and I think highly unlikely, any of the charges will go to trial before the election.
Really? See, I was going to ask you that. And you know, I understand that when we look at sort of the counts that the president is facing and the things that he's being accused of, there is kind of an overlapping between the public and the private. And you know, one of the things that the court is going to have to determine is for each decision that he made, whether it's, you know, pursuing a legal challenge in a certain state or the fake elector scheme or talking to the vice president, was he operating as a private citizen in his own best interest? Was he operating as a candidate in his own best interest? Or was he operating in the best interest of the American people as the president? And there's a lot in between.
There's a lot there. And you're putting your finger right on the problem that Judge Chutkan is going to have to address. So the Supreme Court took another step on that. Not only did it say, hey, look, the president is entitled to absolute immunity for official acts, but not for private acts. But it said the president is entitled to a presumption of immunity. And it's the government proof to rebut that. So that means it's not a question whether you or I, Judge Chutkan, thinks one way or the other way, official act versus private act. No, there's a presumption of immunity that applies. It's up to the government to prove during those hearings that those acts were purely private. If the government can't carry the day, then those charges are out and the president entitled to immunity.
Just a reminder, you know, to the public, that a lot of times when the president was talking about legal action, he was consulting with his personal private attorneys. He was consulting with Rudy Giuliani or Eastman, and they were sort of giving him guidance. Scott, I want you to stand by for a bit because you've got CBS News campaign reporter and attorney Katrina Kaufman standing outside of the courtroom. This is one of the most consequential cases of the session. Let's talk a little. This was a 6-3 decision, and the dissent written by Sonia Sotomayor was scathing.
Yes, I'm still reading through that, but there's this very powerful line that she said, with fear for our democracy, I dissent. And as you've been talking about, this is an incredibly consequential ruling. And I think another thing is that we could potentially see a sort of mini trial take place before the election as Judge Tanya Chutkan weighs what can still qualify in this indictment. And so potentially that could have witnesses, and the country could see this trial play out in some form without a jury. But a really important thing that the Supreme Court has taken away here is that they're saying protected conduct can't even be introduced as evidence. And I think that that is a much more stringent line they've created than anyone was expecting here, because it seemed as though even if there were some acts of official conduct that couldn't be prosecuted anymore, that Smith would still be able to weigh those as evidence before a jury in a trial.
So then, this begs the question about the timeline. I mean, we already knew that the timeline for this trial, or maybe no trial at all, was extended. The Supreme Court heard arguments in April, and there was all sorts of pressure to speed this process up. They chose instead to give us a decision on the last day, and it might very well be the last case on the last day of this session. The likelihood of any kind of decision, even whether or not it's to go to trial, happening before the election, I feel like it's getting slimmer and slimmer.
Absolutely. I think at this point, given what I've read so far, the actual trial seems impossible before the election. It looks like it would get pushed to 2025, but we could potentially see the mini trial that I was just talking about in the coming months. I think another thing that's important to point out is that this is supposed to be an originalist, textualist Supreme Court, many of these justices, and this is really not what the framers intended. They had come from a monarchy where the king had absolute power, and they very consciously did not write presidential immunity into the Constitution.
That was fantastic, Katrina. Thank you so much. We're going to bring in CBS News chief legal correspondent Jan Crawford. Jan, speed reader extraordinaire. The way you dig into this stuff is just—it's always I'm always so impressed by you. And one of the things that you were sort of reading was the dissent. And it's quite powerful words. Can you talk a little bit about what Justice Sotomayor had to say? But also, I want to hear the counter argument from the Chief Justice.
Yeah, I mean, I think Katrina just explained what the dissenting justices believe, that this is not in the Constitution, and that the framers were very worried that our president is not a king. And that is reflected in the dissent. That is not what the court believes. They believe that this is baked into Article 2 of the Constitution. They see there's a serious separation of powers concern, and that is the power of the president to actually function when you may have bitter political rivals and the climate that we're in. That is a concern of this Supreme Court, and specifically this Chief Justice, who does take a pretty expansive view of presidential power. He always has. This decision is not a surprise. It's not a surprise that the Chief Justice wrote it. It is not a surprise that they found some immunity here for, unofficial acts, and that's going to be up to Judge Chutkan to kind of determine that based on the roadmap that they've laid out. It is not a surprise that they've rejected Trump's sweeping claims that he can't be prosecuted for anything because he was never convicted in his impeachment trial by the Senate. So, they've rejected like some of the far extreme claims that Trump made. They have rejected the other side, where, as the dissenters had hoped they would do instead, they rejected that there is absolutely no immunity whatsoever. And again, they've divined this kind of middle path, which we've been expecting based on those arguments. And, it's now going to go back to Chutkan. There is a roadmap. I absolutely agree with what Scott said earlier in your show when you were talking to him, that Jack Smith could well decide that he's going to retool this indictment, because Trump's lawyers did concede during the argument that there were a number of allegations in the indictment that were unofficial acts. So there is a prospect that he could retool that indictment and argue that we can resolve these matters pretty easily, and let's just go forward on this. That's up to whatever Jack Smith does. This will take some time. There will be a little gap. We've got a week or so before it's going to get back to Chutkan, and then I think we're going to see things heat up pretty quickly after that.
I thank you for sort of reminding us of what Donald Trump and his attorney's argument was, which was that there is already a legal framework in place when a president behaves criminally or behaves badly. It's called an impeachment. And if a president is impeached, then perhaps you could then later on pursue criminal charges. But without an impeachment, you can't.
Well, without a conviction, yeah. Like he's saying he was never convicted, so therefore, like, sorry, you're out of luck. And I mean, obviously, the conservatives, even during argument, were saying, like, okay, but what if this was at the end of his presidency and there was no time to impeach him? Like, that's ridiculous. So it's clear they were going to reject that during their argument. I thought there were, and as you can see today, none of the conservatives are embracing that either. So again, we're back to where we started, which is what's Judge Sutcliffe going to do in determining what is official and unofficial acts. The court has given her some guidance on that, but this is not the decision I think that John Roberts would have wanted. He does want to convey that the court speaks with more unanimity than some of their decisions would suggest, that they're not, at each other's throats all the time up there anymore. It's not divided by politics, but instead you got that fiery dissent by Justice Sotomayor suggesting that, at least for official acts, the court is saying that the president is now like a king. And that was joined by the two other liberal justices. That, for the Chief Justice perspective, would be suboptimal, to say the least. I'm not going to call it an oversight by the framers of the Constitution, but it sort of was surprising to me that that this wasn't more clearly defined. Whether or not a sitting president could participate in something that was considered an illegal act. And it seems like now, at least, no matter what side you're on, there are at least some rules of the road now. Absolutely. And I mean, obviously, some of the concerns that came up in the lower courts and in the Supreme Court was, the hypotheticals about what if a president ordered SEAL Team 6 to assassinate a political rival. I mean, obviously, even under this court's ruling, that would be considered unlawful, and the president has no authority to commit murder. It's a violation of the military law and also an executive order that prohibits assassination. So that would be unlawful conduct that's not authorized. So, I mean, I think, even though some conduct now is entitled to immunity if it's an official act, much of that is out of bounds, and I think now it's going to go back to Judge Sutcliffe, as we've been discussing.
All right, so thank you so much, Dan. We're going to bring in CBS News Chief White House correspondent Nancy Cordes, standing outside. So, Nancy, the president has really chosen not to weigh in on any of the former president's legal challenges. The Biden campaign may be a little bit of a different story. Are we getting any reaction either from the administration or from the campaign?
No reaction from the White House yet. I do anticipate we will get something from them as the day goes on, even though you're right, the president himself has tried to steer clear of talking too much about any of these cases. And on this case in particular, he's barely said anything at all. At one point, he was asked whether he thinks that any past president should have been immune for things that they did. And he said, I can't think of one. But that was about it. But we do have early reaction from the Biden-Harris campaign, a senior Biden campaign advisor saying that today's ruling doesn't change the facts. Let's be very clear about what happened on January 6th. Donald Trump snapped after he lost the 2020 election and encouraged a mob to overthrow the results of a free and fair election. So they want to bring this back to what this entire case was about in the first place, which was the January 6th insurrection and Donald Trump's actions leading up to it. We expect to get more as they kind of digest this ruling and what it means. But in the meantime, we are starting to get some reaction from other top Democrats, including Jamie Harrison, the chair of the DNC, who posted online. He quoted a snippet of that fiery dissent from Sotomayor saying, with fear for this democracy, I dissent. And then he added, simply frightening, may God have mercy on this nation. So that's the kind of language you're now hearing from Democrats who say that this ruling fundamentally changes the relationship between the president and the people he or she serves.
Well, I think we heard a post from the former president, Donald Trump, who's already sort of kind of couching this as a win for him. And you've given us a little bit of an indication as to how the campaign, and there you have the post right there from Truth Social, big win for our Constitution and democracy, proud to be an American. So you've given us an indication as to how the Biden campaign is couching this. So far, they haven't actually been successful when it comes to capitalizing, you might say, on some of the legal challenges that Donald Trump has faced. Or I don't know if they haven't been successful, but Donald Trump has certainly figured out a way to make it work for him. Here we are now where he's characterizing this as a win. How will the campaign, do we expect, use this to galvanize Democratic voters? I think we hear a little bit of what it's going to sound like.
You know, I think that they're going to concede that this is a win for him, and they're going to make the case that this is all the more reason why Democrats need to support President Biden if they want the opportunity in the next 4 years to potentially name Supreme Court justices who are more middle of the road. We don't know if the next president will have that opportunity or not, but certainly it brings the issue back front and center for any Democrats who maybe had sort of become accustomed to some of these Supreme Court rulings, like the Roe v. Wade rollback that's now 2 years old. This is sort of fresh evidence for the Biden campaign that that democracy itself is on the ballot and that the Supreme Court is an issue. So they are hoping that it will fire up their base. Obviously, they would have loved for this trial of Donald Trump around January 6th to happen before Election Day, that they felt not only that it was something that voters deserve, but also obviously would have underscored the fact that he is facing legal scrutiny on so many fronts. Now, thanks to this ruling, what was a very slim chance has now all but evaporated. And yet it does still bring the issue back front and center, and I think the Biden campaign will do what it can to capitalize on that. In fact, they've just got a new ad out this morning in which Joe Biden hits Donald Trump for the things that he said about January 6th on debate night just a few nights ago.
I'm sure people will be getting text messages and emails soon asking for money. That's how it works.
They already are. They already are. I've already seen one request go out, and I'm sure there will be more to follow.
Wow. All right. Thank you so much, Nancy. We're going to bring in CBS News legal contributor and professor at Loyola Law School, Jessica Levinson. Been waiting to pick your brain. Jessica, are you surprised at all by this ruling?
I get to say I'm not surprised just because we got to talk about this case so much, and we saw the filings and we were able to talk right after the oral arguments. And I think that while there are a few things that maybe I was a little bit surprised about, I'm not surprised that the Chief Justice wrote this opinion, that there was a finding that presidents are entitled to some immunity, and that immunity is based on when presidents take official acts. And I don't think it's a surprise that Justice Sotomayor wrote the dissent. I can screenshot my text from an hour ago to say, yes, I'm not surprised. We basically got it right, but that's only because the justices telegraphed what they were going to do in the oral arguments. And I do want to emphasize that, yes, while this is a huge decision, it's a matter of first impression, the court did have a bit of a roadmap based on civil cases filed against presidents. So go back all the way to President Nixon. And what the Supreme Court said decades ago is if you try and sue a president for monetary damages based on official acts, you can't. Because presidents are different, because they have different responsibilities. We don't want them to live in fear of frivolous suits. And you see that thread, I think, come today in the opinion where there's an acknowledgement that presidents can be subject to retribution. And we want presidents to be able to function without putting them completely outside of the accountability of the law. And I think that's what we see the majority trying to do today, is figure out where is this line where there's protection versus where there's not protection.
So in terms of the consequences, I see kind of two buckets, right? There are the consequences as it pertains to the trial that Donald Trump is facing right now for what he did in attempts to change the outcome of the 2020 election, and then consequences beyond that for future presidents. So let's start with the current case that the former president is facing. What sort of consequences do you foresee?
So with respect to the case against the former president, the Supreme Court, and this is a place where I actually am surprised, they went into more detail about the portions of the indictment, the allegations, and whether or not those look like official conduct where there's presumptively there's immunity, or whether or not it looks like there's unofficial conduct where there is no immunity. And so the court went through things like pressuring the Department of Justice to try and overturn the outcome of the election, like pressuring the vice president to use his ceremonial power on the day of the certification of the Electoral College votes to throw that into chaos. And then they also went into things like the president talking to people outside of the executive branch, to state elected officials, to private citizens. And in each case, they gave Judge Chutkan, we keep mentioning Judge Chutkan, she's the trial court judge overseeing this case. They gave her a roadmap, and they talked about whether or not those acts look like official acts, again, where there's presumptive immunity, or whether or not they look like private acts, acts taken by a candidate or by a private citizen, not by the president of the United States. And Anne-Marie, I think to all of your excellent questions, the guiding principle is going to be, is the president acting pursuant to either constitutional authority or authority granted to him by Congress? And then it looks like the president is engaging in an official act. If not, then we have a much more robust argument for this isn't an official act, this is a private act.
And it looks like the judge in his case, that's exactly what she's going to have to be looking into and hearing arguments about. Thank you so much. That was so illuminating. I know we're going to continue to talk about this probably throughout the afternoon. In the meantime, though, I'm going to go to CBS Chief Election and Campaign Correspondent Robert Costa. All right. I guess I'll get your reaction to this decision, Robert.
Good to be with you. This is a significant legal crossroads as well as a political crossroads. The fallout already playing out in the Democratic Party and the Republican Party. Democrats outraged largely by this decision, believing that former President Trump is not going to be held to account before the election, and they believe that the conservative justices on the Supreme Court are effectively, with this ruling, helping Trump ahead of the election evade scrutiny on his conduct on January 6th and about his handling of classified materials. Meanwhile, in former President Trump's campaign, there is a lot of optimism that he can now proceed without having the Supreme Court and these federal trials over his shoulder. At the same time, there is some apprehension that he still faces this upcoming sentencing in New York on July 11th. In that criminal case over hush money payments. He stood trial earlier this spring, as we all know. We covered that deeply, and he could still face a jail sentence. So in one sense, he is okay today on the federal level in terms of what he might face before the election. On another front, though, he still faces possible jail time.
I mean, yeah, it seems as if Donald Trump and his campaign are characterizing this as a win. I kind of view it more as a clarification, that, yes, there are acts that are protected. There are acts that are within the constitutional responsibilities of a president. But that doesn't mean everything you do while you're in the White House is protected in that way. But they're already calling this a success for them, for Donald Trump.
It's hard. I would argue as a reporter against making any kind of firm conclusion about what this all means. In a sense, the opinion, it does provide a roadmap to a point to Special Counsel Jack Smith as he proceeds to try to continue to move this prosecution forward, albeit perhaps at a slower pace than he might have liked in the last few weeks. At the same time, you're looking at a former president who now has a lot of presidential power potentially should he win again. And that is making Democrats alarmed about what is possible. And look at the language, as I've been discussing with Jan Crawford, and she's noted in the special report, the language of the dissent by the liberal justices. They are framing the stakes as so high here that this is not just some kind of academic ruling on presidential power. They are warning through their dissent the entire country, the legal system, that the president under this ruling, could now act as a so-called king, a monarch, without any kind of constraints on many different issues. And this is something we haven't seen, this kind of charged language in a dissent for a long time. And this is matching what many Democrats and some independents and even Republicans feel, those like former Representative Liz Cheney, that Trump would be unbound if he won power again, that he would, on so many issues, push the line of presidential power and feel like he had the blessing of the Supreme Court at his side.
Well, Robert Costa, there's still sort of a little bit of a ways to go. And we had talked a little bit about the special prosecutor perhaps amending some of the charges in order to fit within the confines of what the Supreme Court has concluded. Is there, I mean, can we say now that the prosecution of Donald Trump for his involvement in attempting to throw out the results of the 2020 election will continue or not? Or is there still a big question mark?
There is a question mark, but we do know that Judge Tanya Chutkan in Washington, D.C., on a federal judge, and Special Counsel Jack Smith are by no means going to abandon the possibility of a trial here. It's going to be slowed by the Supreme Court's ruling with different hearings and a process that's now put in place to evaluate what's possible under the law, under this ruling, in terms of presidential power and presidential acts. But I have not seen any sign, though there's been a no comment from Special Counsel Jack Smith. You can see there's no sign that they're somehow going to walk away from the potential of prosecution. I know Jan wants to jump in as well.
Well, I just think, I mean, once again, that's an excellent point. I mean, I agree with everything Bob is saying. And I think when we think about the timing here, you know, there was some frustration that it took, you know, Merrick Garland so long to kind of get things going on this prosecution, because Jack Smith wanted this done by the election. Democrats wanted this done by the election. But if Trump doesn't win, Jack Smith can prosecute him after the election. I mean, he's still there is, you know, there's arguments that sitting presidents cannot be tried while they're in office. But there is nothing that would stop Jack Smith, if Biden wins in November, from trying Trump in January, where right now he's facing charges that, at least Smith will argue, carry up to a 20-year prison sentence. So, you know, the idea, I think, the court did expedite this case. Smith asked them if they were going to take that up, to please take it up and have a decision before the end of the term. He knew that was going to be the timeline. I think he was very, very aware that this is exactly how the court was going to rule after those arguments. And he's a really smart guy. And I will be very surprised if he is not ready to go with something that he's going to file with Chutkan to say this can now move forward and we can still get this done by November. My point is, though, that's not to say that it couldn't happen after November. There's nothing that says this case goes away, as Bob was saying, after the election, unless, I mean, Trump wins, and then they would have to wait. Presumably, there are arguments they'd have to wait until he leaves office again.
Right. Robert, Jan, thank you so much. And I want to thank everyone for watching our continuing coverage. We're going to continue to discuss this landmark decision about the Supreme Court ruling that former President Donald Trump does enjoy limited immunity for official acts. We're talking about acts that are within the core constitutional powers of the president. Stick around, much more ahead.
Go to the ends of the earth.
Right now.
We got something crazy. And reach for the stars.
Here we are.
Time.
Yes, it's my comeback.
Hey, this is pretty fun. But wait, there's more.
Experience thought-provoking.
I'm open to the idea of being a human being.
Innovative and truly original reporting.
Look through a telescope and go, wow.
Because there's always something new under the sun on CBS Sunday morning.
At this moment, terrorists could be plotting another attack.
9/11 triggered a counter-terrorist system that included a secret database.
This person needs a closer look.
A growing list of nearly 2 million people, including some Americans who say they're innocent.
On 1 hour flight, I have to spend 6 hours to go and come back.
CBS Reports explores the system, the people responsible for it, and those pushing for change.
I'm not fighting against them. I'm fighting for them to do the right thing.
The Watch List, now streaming on the free CBS News app.
Don't miss true crime anytime you want, anywhere you go. With the 48 Hours podcast. Real crimes, real lives, real justice.
There's some questions that have to be asked and need to be answered.
Listen to 48 Hours on Apple Podcasts.
An original documentary from CBS Reports.
Imagine yourself in Manhattan with no police, no army, no mayor.
The people of Haiti stare down poverty, corruption, natural disasters, and violence.
90% of the guns that are used by gangs in Haiti are American guns.
But with an unbreakable spirit and eternal optimism.
There are days where I cry, but we can't be discouraged. We still believe in Haiti.
They're still able to look ahead with hope.
Haiti is on the brink of transformation, a radical shift. Haitians are coming together and saying things must change.
Fighting for Haiti, now streaming on the free CBS News app.
Hey there, welcome to The Uplift.
I thought she was a groom, and I stepped back and I went, oh, you're the queen. She's going to be with me every instant that I'm alive.
I just wanted to see if you'd go to Disneyland with me today.
I look over at him and he's smiling.
I'm going to remember that the rest of my life.
They told us when he was going to be born, he was only going to live for 30 minutes. It's really a miracle that he's with us today.
The Uplift. Stream now on the free CBS News app.
When you wake up in the morning, we want to be your go-to team.
On our places, bright, shiny faces.
I don't go to work in the morning. I go for coffee with my two good friends, and we talk about the world.
Your morning routine just got better. CBS Mornings.
A CBS News investigation. People looking for love, finding their life savings gone.
This could happen to anybody.
And sometimes losing their lives. Anything for love. Now streaming on the free CBS News app.
Good morning. Thanks for joining us here on CBS News 24/7. I'm Lindsay Reiser, and we want to give you a live look right now at the Supreme Court. The justices just made a historic ruling in the case of Donald Trump v. the United States, saying, quote, under our constitutional structure of separated powers, the nature of presidential power entitles a former president to absolute immunity from criminal prosecution for actions within his conclusive and preclusive constitutional authority. The decision goes on to say there is no immunity for unofficial acts. We have team coverage of this decision, from what it means for the former president's charges stemming from the January 6th insurrection to the political impact. Lawyers Scott Frederickson and Jessica Levinson are standing by for analysis. We are going to begin with CBS News campaign reporter and attorney Katrina Kaufman. So, Katrina, really what comes down to it to me is the difference between official and unofficial acts. How does the decision lay out the difference between the two?
So the opinion makes determinations about certain of Trump's acts, but really what they're doing is sending this back to Judge Tanya Chutkan to make determinations about what can remain in this indictment by special counsel Jack Smith. What was Trump acting as an office holder versus acting as an office seeker? And this creates a really, really significant precedent for our country, that a president will be immune for what is determined to be his official acts. He will have absolute immunity for his core powers, and then for any other official acts, there's presumptive immunity. So it will be the government's job to prove that those acts can be qualified as unofficial. There's also separately a really important footnote that I saw in this opinion, which affirms the Department of Justice's OLC position that a sitting president cannot be prosecuted. And this is something that has been a precedent from the past, but has never been officially affirmed by the Supreme Court. This actually raises the stakes of this election for Trump, because it means if he's elected in November and takes power, none of these criminal prosecutions can proceed against him once he is president.
And so, Katrina, just to remind everybody how we got here, I just want to remind people some of the key important dates here. Remember, I believe it was August 1st of 2023 that these charges by Jack Smith's team were officially filed. We know some other key dates. For example, October 5th, this was the first time that Trump filed the motion to dismiss on immunity grounds. And then there were some filings in December. Jack Smith's team asking to sort of circumnavigate the Court of Appeals, the Supreme Court denying that, and then ultimately the Supreme Court agreeing to take up the case this session. So while it seems like the timeline for a trial before the election could be in jeopardy, help us understand the speed with which this has been adjudicated, the fact that the Supreme Court did actually agree to take this up this session.
So the timeline you're laying out is really important. And as you mentioned, Jack Smith had first asked the Supreme Court to take this up back in December. That is 6 months ago. They said that it wasn't ready for them to make a decision on. They had the D.C. Circuit make a decision. The D.C. Circuit found that there was no immunity for the president. Then the Supreme Court decided to take up this case, heard arguments in April, and we now have a decision. And of course, this is them moving quickly compared to a normal timeline. But given the expediency which they've handled other presidential issues, such as when Trump was potentially going to be taken off the ballot in Colorado, they determined that within 2 months. Or with U.S. v. Nixon, they determined that within 54 days. So they've now put this case in complete jeopardy. It's very, very, very unlikely that it will take place before the November election, given the vast amount of work that Judge Chutkan has to do. The best possibility for Jack Smith at this point, with laying out these charges in any form before the public before November, is to potentially have a sort of mini trial where they make determinations on what can remain in this indictment. And it's possible that could include witnesses and evidence, potentially even Trump himself testifying. So I think that that is the closest that we might get to an airing out of any portion of this indictment before November. But another important thing that the court has done here is that they've also taken away Smith's ability to use official acts as evidence. And so that is really going to slim down his charges against Trump.
So then, would that mean that we would likely see a slimmed down indictment before we see some of these evidentiary hearings in Chutkan's courtroom?
That's a good question. It's possible that Jack Smith has been working on a slimmer version of this indictment, but I think it really is going to be sent back to Judge Chutkan to make determinations. During the Supreme Court arguments, Trump's own attorney, John Sauer, had admitted that certain conduct from the indictment does qualify as private. So I'm sure that Jack Smith is doing everything he can to figure out a way to streamline this, but I think it's still extremely unlikely that this case can move forward before the election takes place.
And these oral arguments were in April, so I'm throwing you a curveball here. Do you recall which specific acts they were talking about when Trump's attorney conceded that some of those acts included in the indictment were private acts?
I know there were about 4 concessions, and some of them related to Trump's interactions with private attorneys, such as with Giuliani. They were related to the fake electors scheme. So all of these, I think, will fall into the private acts category. But the Supreme Court is really making it, with the way they've written this ruling, so that Judge Chutkan is going to have to make decisions on this and how the case can move forward.
And one more time before we let you go, I just want to go down memory lane a little bit. In the D.C. Court of Appeals, the D.C. Circuit, unequivocally saying that former President Trump has no immunity. The Supreme Court could have left it there, but they decided to take up this case and they decided to rule. Can you elaborate a little bit on what the appeals court says? I believe it was a 3-judge panel.
Yes, the appeals court said that Trump had no immunity from criminal prosecution. They said that when he left the presidency, he was no longer President Trump. He became Citizen Trump, and thus criminal charges could proceed against him. That the king, the president is not, a monarch. When the framers wrote the Constitution, they did not give the president immunity. That was a very conscious decision. And during the Supreme Court arguments on this issue, actually, Justice Jackson expressed the concern that the president could become the seat of criminality in this country if the president is allowed to be immune from criminal prosecution. Justice Kagan also brought up a really interesting hypothetical, because Trump's team was arguing that the only way a president could be criminally prosecuted for official acts is if they're first impeached and convicted. And Justice Kagan had said, what if on January 20th, the president orders the military to hold a coup? Then once he leaves office, it's too late to impeach and convict him. Would he not ever be held liable for that type of action? So as many of the justices wrote in their dissent, this is setting a very dangerous precedent.
Katrina Kaufman, thank you so much for your live report outside the Supreme Court. Let's go ahead and now turn to our legal panel. Scott Frederickson is a defense attorney and former federal prosecutor, and Jessica Levinson is a CBS News legal contributor and professor at Loyola Law School. Before we go to you, Scott, to talk a little bit more about the dissent, Jessica, I know you've been listening to my conversation with Katrina. Do you have any thoughts so far?
Yeah. So I think what the Supreme Court did today is answer a question of first impression. And we did not have an answer for when former presidents or current presidents have immunity from criminal prosecution. We had an answer when it comes to civil suits. What the Supreme Court said decades ago is that if a president is sued for monetary damages, again, a civil suit, that president enjoys absolute immunity if we're talking about official acts. So I do want to caution everybody that there's been precedent for decades saying that presidents are different, in part because we fear that they could be subject to frivolous lawsuits, frivolous criminal complaints, that we understand that under the Constitution, as the head of one of the branches, the presidents, frankly, are just different. And I know it's appealing to say that this undermines the idea that no person is above the law, but there's a lot of ways that we do treat presidents as different. For instance, you and I don't get to appoint ambassadors, appoint judges. We don't get to sign legislation. There's just different things, different duties that presidents have. And so while the court today is saying that presidents do have immunity from presumptive immunity for most official acts and no immunity for unofficial acts, I think that roadmap has been there for, frankly, decades. The other thing I would say is that Jack Smith, is this the timeline that he wanted? No, in some circumstances, but in December, he said, I want a decision by the end of the term. He got a decision by the end of the term. He wanted to jump in line. He didn't want the DC Court of Appeals for completely understandable reasons. He didn't want them to rule on this first, but they did. He then didn't want the Supreme Court, to take the case. But they did. This is the type of case that the Supreme Court takes. It's a case where it's going to be in constitutional law books. I'm going to teach this case. I'm going to teach it right after I teach the cases about immunity from subpoenas and immunity from civil suits. And this is going to fit as the end of that particular chapter. So I would say, is it a good day for the former president? Yes. Did they adopt all of the arguments that he wanted? No, they did not. I do not see that in this opinion.
Stand by. I got about a million more questions for you. But Scott, first of all, let's talk about Justice Sonia Sotomayor's scathing, blistering dissent, in which part of it that I want to pull up, she talked about presidential powers. When he uses his official powers in any way under the majority's reasoning, he will now be insulated from criminal prosecution. Orders the Navy's SEAL Team 6 to assassinate a political rival, immune. Organizes a military coup to hold on to power, immune. Takes a bribe in exchange for a pardon, immune, 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 immune. What do you take that to mean?
Well, I think we have to remember that this scathing dissent was joined in by Justice Kagan and Justice Jackson, and their concerns are real. Let me back up and describe why, and throw out for you kind of a nightmare scenario, which I think the Supreme Court has provided, unfortunately, and unintentionally. Here, the court didn't just split the baby down the middle on this. It outlined a very robust, strong immunity for president. In the outermost official acts of a president, according to the Supreme Court, the president is immune. And if challenged, it's up to the prosecution to rebut that presumption. And in a prosecution, the government cannot use the private records of the president or testimony of its advisor. So let me put out one unfortunate, I think, scenario. Our colleague here, our professor from Loyola, has indicated will be teaching this, and I think this is a concern of the dissent. So while it's been rejected that the president can't just go out and shoot someone and be immune, I think the dissent is saying, here, what the president is able to do under this opinion now is this. let's say instead now the president said, it has come to my attention through my advisors and the official agencies that a foreign power has infiltrated our election system, and it is all fraudulent, and has infiltrated the halls of Congress, and they are going to take control. I therefore, under my core constitutional and statutory duties, remember, absolutely immune for that, I am ordering the Defense Department to suspend elections and to take over Congress. I do that as part of my core statutory and constitutional duties. Now, according to this opinion of Justice Roberts, that the president enjoys immunity for. And that's what Justice Sotomayor is getting at. And that's why she's joined by Justice Kagan and Justice Jackson. It's a real concern because the Supreme Court in this opinion has outlined a very robust strength of executive power, very difficult to challenge. So in the future, if a president wants to undertake some, let's say, alleged criminal action, they'll make sure to cloak it under their core constitutional and judicial powers. So I think that's one of the takeaways I take from Justice Sotomayor's scathing opinion. And it's a legitimate question here. How does a prosecutor for a president that tries to take over the government, try an attempted coup, how do you prosecute that under this standard? Now, I do think when we get back to Justice Chutkan in a week, I think you'll see the special prosecutor, Jack Smith, come in, and he's going to tell the court, I've jettisoned any of the allegations and counts in the complaint that have to do with official action. The only charges we're going with now are the reduced charges that only relate to private conduct. And with that, Justice Chutkan is going to conduct hearings. And as your colleague indicated, there's going to be a mini trial. There's going to be testimony. But you're not going to hear evidence from the president's private records or from his advisors. Because remember, the Supreme Court said, can't use that now, cannot use that. And even if Judge Chutkan then says, look, I've decided these very limited remaining allegations are purely private conduct, and I'm ready to go to trial. Well, the first thing that the former president's lawyers are going to do is seek appeal at the D.C. Circuit and then to the Supreme Court, and that's going to delay it as well. So chances of this going to trial, very, very minimal.
And before, Scott, I ask you about how this will impact the other cases, not only facing the former president, but also defendants in Arizona and Georgia. Jessica, I want to ask you about a hypothetical. What does this mean for a hypothetical situation that Trump himself alluded to in the debate in saying that some of current President Biden's conduct, action or inaction at the border is criminal? What does this decision say about a hypothetical like that? If President Biden were to lose the November election and former President Trump were to regain the White House, if he decided that he wanted to go after President Biden?
I think this is such an important question because understandably, we're spending so much time talking about the former President Trump, and the criminal indictment facing him. And that is really important. There's no question about it. But your question goes to something that we heard during oral arguments from the justices, which is we're not just ruling on this particular case. This is a case about every other president and future former president. And to your question about, well, what if Biden was then at some point he's going to be a former president, and then could the Department of Justice be used and arguably weaponized against him or used to file criminal charges? And I think the answer has to be, well, here's our guidepost, right? That there is absolute immunity for those things that only the president can do, those core functions. There is presumptive immunity for official acts. So if this falls within an official act, then here we go. We have presumptive immunity, and you would have to overcome that presumption. And so in that way, you could see this as protective. Again, I know it's so hard to separate the words Trump and Biden. But if we just say President X and President Y, then you can see that this is protective of whoever is in the Oval Office or becomes a former president. And that, I think, is it's an important question because it highlights the importance not just of this case, but every other case, and why I think you see such a lengthy opinion here, because they know that they're writing about more than just one president.
We'll have to ask about the other cases in a little bit. Scott Frederickson, Jessica Levinson, and Katrina Kaufman, thank you. Scott and Jessica, you're going to be joining me again in our next hour. I want to go ahead and bring in CBS News Chief White House Correspondent Nancy Cordes. So, Nancy, you've obviously been listening to our conversation. And the Biden campaign, I believe they released a statement, right? What are they saying?
Right. So they haven't yet released a statement on the content of the ruling itself and how they feel about this immunity distinction that the court is drawing. But they have released a statement that tries to refocus everyone on why this case has gone to the Supreme Court in the first place. And that's that according to a senior Biden campaign advisor, let's be clear about what happened on January 6th. Donald Trump snapped after he lost the 2020 election, and he had encouraged a mob to overthrow the results of a free and fair election. Since January 6th, this aide goes on to say, Trump has only grown more unhinged. He's promising to be a dictator on day one. He's calling for the Constitution to be terminated so that he can regain power, and on and on. So obviously what they're trying to do is to say, hey, look, yes, you're hearing a lot of legal arguments back and forth. The reality is that this all stems from Donald Trump trying to prevent the peaceful transfer of power to Joe Biden because he was angry that he lost. And they've even got a new ad out today that, in the president's own words, he hits Donald Trump on what he said about January 6th at the debate on Thursday night. Obviously, the Biden campaign here trying to refocus away from the challenges that Biden himself had at that debate and remind Americans of some of the false claims that the former president made on debate night about January 6th, about immigration, about the economy, and on and on.
And this kind of brings up an important point that Anne Marie and Jan were talking about prior to us going on the air about 20 minutes ago, and that is that if Trump loses, there's nothing to say that a trial couldn't begin once Biden stays in the White House. I mean, I guess if Trump were to be the one that were elected, that would throw the wrench in terms of a trial.
Sure. And I think, obviously what the Biden campaign would have loved would have been for this trial to go forward before Election Day, not only because it would keep Trump's legal problems front and center, but also because they argue that this case is central to democracy. The fact that a sitting president would try to overthrow a free and fair election, that he would encourage people to storm the Capitol. They think that that the outcome of that trial would have been something important for voters to know about before they cast their ballots in November. That's obviously not going to happen. I don't think even before today's ruling, most officials in the Biden campaign or here at the White House thought would happen. They knew the chances were very slim, but I anticipate that when we do get a statement from the Biden campaign, they're likely to argue, as we've been hearing so many Democratic lawmakers argue already this morning, that it fundamentally changes the definition of the presidency. It changes the relationship between the president and the people that he serves or she serves. And they are going to argue that this is yet another case of the Supreme Court putting its thumb on the scale for former President Trump. And finally, I think they'll make the case that this is why it's so important for their supporters to stick with President Trump, despite some of the challenges that he may have had last week in the debate, because one of the things that a president gets to do is name new justices to the Supreme Court if anyone retires, and that's obviously a possibility over the next 4 years.
Nancy Cordes, thank you so much for your time. We have more coverage of this historic ruling after the break. Stay with us. You're streaming CBS News 24/7.
Okay, so let's just start at the beginning.
Well, let me start with this. What is at stake here?
What is the answer then?
Do you know why? You want me to just keep going?
Is that a good thing or a bad thing?
Were there death threats?
How is this possible?
What's wrong with that argument?
Are you saying they lied?
Have you told the government that? Why won't you say the word crisis?
You're not answering my question.
This really
Is that scary?
Does that make sense?
What do you mean?
What does that mean in
Did
English?
any of that make sense?
What's your response?
What happened?
Why?
It's time for the CBS News Original 60 Minutes, Sunday on CBS and streaming on Paramount+.
There is no more room in our city.
New York City is receiving record numbers of migrants.
Today, we're going to have more than 500 adults and children come through that door.
Tensions rise as shelters reach max capacity.
We don't have to take care of them.
CBS Reports goes inside a crisis cities and families are facing as they fight to survive.
The United States still has that glimmer of hope for people to come here.
Fighting for a future. Now streaming on the free CBS News app.
On Face the Nation, the way to learn is to listen.
We may have a recession.
Listening to how someone explains themselves is so key to understanding their perspective.
An original documentary from CBS Reports.
Since you started La Soup in 2014, do you have any sense as to how much food you've rescued from the landfill?
We've rescued 4.5 million pounds.
I can't even fathom how much food that is.
And that's one little person in one little city in America. We're going to call this chicken piccata. We did 450 of these meals today.
This is the exact dish that you and I are going to have.
Yep.
Oh, really good.
Is it good?
Mm-hmm.
Having a plan of how to keep people fed should be in every single city.
If we eliminated food waste, could we eliminate
hunger? Yes.
Eating Trash, now streaming on the free CBS News app.
America Decides, taking you inside American democracy.
The most important stories on a day-to-day, hour-to-hour basis.
You're going to hear a lot of reporting.
It is clearly a pivotal moment.
Gun control, the economy, education. Both sides of the political aisle fight it out for power.
Bringing you the analysis that you need.
Thoughtfully, with context.
Be part of the conversation.
On CBS News streaming.
Welcome to America Decides.
When people say who's first to get in the morning, that would be me. Morning news matters because it sets the tone for your day, and it's a way of getting you